Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, and good morning, everybody. Welcome to the Appeals Court online virtual session on Thursday, November 21st. I'm the panel chief today. I'm Justice Massing. My pronouns are he and him. With me together is Justice Henry and Justice Grant. And we have on the screen, is Mr. Gibson, is that the correct way to address you?
Yes, it's Mrs. Gibson, transgender.
Mix?
Mrs. Gibson, I'm transgender.
Mrs., okay. And Attorney Glazer?
Yes.
And so I just real briefly, we try to do this as much as we can, like a regular argument. So it's 15 minutes per side. Ms. Gibson will go first. Attorney Glazer will go next. There's no rebuttal, so take you 15 minutes. We ask the party who's not speaking to mute themselves, but to stay on so we know they're there. And at the same time, since we can see you, please keep any reactions to a minimum. And we're familiar with the materials. We've read the briefs, so you can go right into it. And with that, I'll call this case, which is docket number 23P1048, Darius Gibson versus Commonwealth and others. So, Ms. Gibson, you have the floor. And there's a clock. There you go.
Okay, Your Honors, in this present case, the prison librarian and the prison itself has a regulation or a policy that states photocopying services are for reproducing legal documents to be filed with the court for criminal litigation related to one's sentence and other legal documents upon showing of legal need. Now, I ask you, Justices, one question. Is the definition of legal documents only documents that are to be mailed to the court? The answer is no, a petition is a legal document. I'm here before you today because I wrote the Boston Police Department I sent them a public records request. They responded to me to give us 30 days, we'll mail you the documents you're requesting. What happened was after 30 days, they did not mail me the documents. So what I did was I appealed to the supervisor of public records. Now, in order to do a appeal petition to the supervisor of public records pursuant to 950 CMR 3208, and you must mail the supervisor of public records the written request that you mail for public records, the response you receive from the government agency, and a brief letter detailing the reasons of appeal. Now, in the prison, I submitted my documents for photocopying, and the prison librarian denied me the photocopy, stating that a petition for the supervisor of public records does not fall under the definition of a legal document for photocopy. Now, my second issue, which I bring to you, is that
So the idea was that you wanted to send your original request, but you needed to keep a copy to prove you had made it?
What happened, Your Honor, was I didn't need a copy for myself. The Boston Police Department mailed me a response letter stating that they were going to mail me my public records request in 30 days. 30 days went by, I didn't hear nothing from them, so I petitioned the supervisor of public records to order them to give me my public records response. Now, in order to do that petition, I would have needed to mail a photocopy of the response from the Boston Police Department to the supervisor of public records. And I submitted this to the prison librarian, and she says, this isn't being mailed to court. This is being mailed to the supervisor of public records. This isn't a legal document. I'm not photocopying it.
I want to clarify Justice Henry's question. I think so. You had a copy, but you didn't want to part with your own copy, your only copy, right? You needed
yes, Your Honor. And also, as you're aware, when you do a public records request / petition, in the event, you have two options. You can either mail it to the supervisor of public records, or you can seek a declaratory judgment in the Superior Court in order, get the Superior Court to order the government agency to do that. Now, I didn't want to initially just jump into court. I figured I would write the supervisor of public records and get the supervisor of public records to do it. And then if I wasn't successful with the supervisor of public records, then I would go to Superior Court.
Gotcha. You could even go to the Attorney General's office between that stage. So let me ask you, as I understand your complaint, you eventually did get the copy, right? But it was with conditions.
I brought this attention to the prison superintendent, and he tries to run DOC Gardner facility as a drug-free DOC facility. He employs dozens of confidential informants, and he said to me, I will give you photocopies if you keep your eyes open for me and let my officers know, let the Inter-Perimeter Security Investigation Unit know if you come across any inmates dealing or using drugs. And so I said, okay, fine, I'll do that. I really needed my copies because I'm trying to overturn my criminal conviction. So I said to him, yes, I'll give you some information. I'll keep my eyes open. And he said, okay, fine, I'll tell the CPO, the caseworker, to provide you photocopies. Now, he basically intimidated and coerced me to be an informant for photocopies.
So just so we're clear about this, what was the time lapse between when the librarian denied you the copy and when the correctional officer asked you to agree to be an informant and gave you your copy?
I'd be lying to you if I told you it was the exact date, but the exact specific date, but it had to be within 72 hours. I brought it to his attention.
And it actually wasn't just, it was superintendent, right?
Yes, Matthew Givers. He's yes, the superintendent Matthew Givers, yes. He's a defendant in this matter.
So between that, I'll be I know maybe you were going to get there, but so when you had this a disagreement with the librarian, and you said to the librarian that you were going to report her or something, right? And that's when she called you a snitch.
Yes, and as you're aware, yes, she called me a snitch because I told her that I asked her to photocopy a grievance that I was filing in the institution against her because she didn't like the way that I was vocal, telling her that the policy, her library policy, and her version of what is a legal document conflicts with 950 CMR 32008 for the supervisor.
She was accusing you of snitching on her. She
Yes.
wasn't accusing you of being about snitching on other inmates.
No, that is a separate issue. That was, if you go to page 10 of my complaint, the superintendent asked me to be an informant in exchange for photocopies, but the prison librarian, when I told her that I was going to file a grievance against her and her policy of the librarian, she called me a snitch for writing a grievance on her.
Right, so I think what we're trying to get, go ahead, Judge Grant.
I have a question about that. So in paragraph 16 of your complaint, it says, after defendant Murphy declined to provide plaintiff photocopies, plaintiff asked for photocopies of a grievance about you mentioned the grievance about her denying the photocopies. At that instant, Murphy said very loudly in front of a lot of inmates, "Go ahead and rat on me, rat snitch, it does not do anything." I understand there are cases that say that it's problematic for a prison employee to label an inmate a rat snitch in front of their other inmates. But as far as I know, that's usually when the inmate is being labeled a rat snitch for ratting on other inmates. Is it as problematic if the inmate is being labeled a rat snitch for ratting on a prison employee?
Your Honor, I haven't found any specific cases that state that. The relevant case that I rely on is the case that I mentioned in my appeal brief, Urban versus Dormier, which state a prison guard should have known labeling an inmate a snitch violates their constitutional rights under the 8th Amendment. And the prison officials are bound by the 8th Amendment to take reasonable measures to guarantee the safety of an inmate. There's never been a case where a prison employee, such as a librarian, calls an inmate a rat. I couldn't find that in the LexisNexis library.
Right, but there is a case, and I know you have maybe limitations on your access, but called Reeves versus King, which is from the Eighth Circuit, 774 F 3rd 430, and they make a distinction between informing in a way that's likely to get retaliation, and in that case, informing on a staff member for violating the rights of prisoners. And so why would you be in danger from other prisoners if you're calling out an employee for violating prisoner rights? Why would that hurt you?
This is the thing, Your Honor. We're in the library surrounded with other inmates. Inmates that were like sitting multiple chairs away, they don't know that I'm currently arguing with the librarian over her photocopy policy. All they might hear is her calling me a snitch out loud, and then now my reputation at that prison is being placed, and my safety is being placed in jeopardy because they don't know the full story between me and her. They just hear that prison staff calling me a snitch, and that puts me out there. They don't know the circumstances of why she's calling me a snitch. It's sort of like saying, Your Honor, if you hear someone say, for example, he's drunk, or he was drunk. I used to start the plural saying he was drunk. Somebody might think that I'm drunk right now instead of me being drunk hours earlier or previous day. They just overhear a little bit.
We understand the word is a very inflammatory word in any context, but particularly in a prison context. The department is arguing that since you're no longer at NCCI Gardner, we should not decide this case. What do you say to that?
As you're aware, Your Honor, under Mass General Laws 231, a prisoner may bring a claim for declaratory relief if the issue is subject to repetition. This is an issue that can affect not just me, but dozens of other inmates who might need photocopies from the supervisor or the supervisor of public records for a public records petition pursuant to 950 CMR 3208. So this issue doesn't only affect me, in Your Honors. This is the issue. Nowadays in prison, is very few inmates that know how to challenge the law and know how to bring issues to a court. So you might come. So this issue is possibly likely for repetition. It's just a matter of when is it going to become before the court system.
Could you be transferred back to NCCI Gardner?
Yes, I could, Your Honor, in the relevant future.
The department argues that you did not make any allegations against Commissioner Mishi in her individual capacity, that you really were only arguing about her in her official capacity. It helps when you bring a complaint to know if you're naming an employee as an individual or in their official capacity or both. So what do you say about Commissioner Mishi?
I must apologize to the court for that one there, mentioning Commissioner Mishi. But the thing is, Your Honor, is Commissioner Mishi, to my knowledge, I was told by other inmates at NCCI Gardner that they had wrote letters complaining about the prison library policy to the commissioner's office in an attempt to get it changed. I personally didn't do that. I was relying on the word of other inmates on that. So I apologize to the court. I'm suing her in her individual and official capacity because I was told that she has knowledge of this issue.
So I'm sorry, you sued her just in her official capacity or both, individual and official?
Both, but separately, because I was told by other inmates that she was aware of the photocopy policy and she refused to change it.
Okay. Were you harmed by the delay in receiving the photocopies?
Yes, I was, Your Honor.
Can you explain?
Here's the thing. This whole circumstances regarding me petitioning the supervisor of public records, I was convicted of first-degree murder. a crime I did not commit. So I'm trying to request, I'm pro se, I'm trying to request my own court documents so I can pro se try to get back in the court and overturn my murder conviction. And this delayed me from doing that.
Remind me, have you had your direct appeal yet, or you're still waiting on that?
I've had my direct appeal, I believe it went in front of, I believe I remember your name, actually. I've already had my direct appeal, but now I'm going to go on my federal appeal.
So on your claim under the Massachusetts Civil Rights Act, the department argues that the defendants have qualified immunity. I don't know if you know much about that, but I wondered what your response was to that.
Your Honor, being a pro se litigant and arguing that qualified immunity, it's on me to point out that they violated the law, and it's pretty evident that my civil rights are violated, outing me as a snitch. That's threatening my personal safety, so threats fall under the violation of a civil rights violation, so they don't have immunity to endanger my safety.
Okay.
All right, you have 30 more seconds. Anything else you want to tell us?
No, that's it. No, that's it. I pointed out everything I would like to.
Okay. Any other questions from the panel?
Thank you. It was really helpful.
Thank you, Your Honor.
So can I ask you to go on mute, and we'll hear, but stay with us. And if you can manipulate that, I don't know if you're able to there, but there you go. Okay, we got you. We'll hear from the Commonwealth or DOC.
Good morning, Your Honors. Daryl Glazer from the Department of Correction on behalf of the appellees. 103 CMR 478, which is the duly promulgated regulation entitled Library Services, and specifically 103 CMR 478.06 defines original legal documents as original documents to be filed with the courts in support of criminal litigation challenging the inmate's sentence directly or collaterally, or in support of civil litigation challenging the conditions of his or her confinement. And then,
but what about other original legal documents upon a showing of need? So are you really saying they can't get a photocopy related to a Freedom of Information Act request?
so Your Honor, no, because it's the NCCI photocopying procedures talks about the showing of legal need. And copying something to go to the public records, supervisor is not necessarily legal need. It's more of a situation where I can give the court direct experience that I've had in another one of my cases where there was an inmate challenging the visitation orders of his children. And now that doesn't follow under, challenging his sentence or civil litigation, challenging the conditions of his or her confinement, but that was a
Custody of his children isn't going to affect his conviction. A public records request is. It's a necessary step before filing a motion for new trial.
But Your Honor, in this situation, the plaintiff could have, sent the letter he received from the Boston Police Department. He could have challenged it in court to get his.
So he could send his original Boston PD letter to the supervisor of public records, never to be seen again?
That's not necessarily that. I mean, they have the record. They would keep it. They would have it. Your Honor, we're, currently, as of yesterday, NCCI Gardner had 850 inmates. Sousa Baranowski, where the plaintiff is currently housed, had 1,073 inmates. The department has to be able to interpret its own regulations and not photocopying all the requests. This is not before the court, but there are numerous requests. Every inmate wants copies of grievances, of letters, of everything they sent. This is the department is entitled to the interpretation of its own regulations.
Right, but you're saying he could just get around this by filing a lawsuit, so you're just moving the burden of to the different part of the Commonwealth and creating an entire lawsuit rather than just letting him try to take a reasonable step to avoid litigation.
But Your Honor, where does it end? You have, if we're going to go back to,
If you're saying the way that he can get around it is to file a lawsuit, then that might say to a reasonable judge, it ends right there, because that's far more burdensome on the Commonwealth than just making one photocopy.
but Your Honor, it's not
Even
just
if it were 872 photocopies, depending on the institution.
it's not just one photocopy. It's numerous inmates would be asking for copies of their public records requests. And
If they're related to a possibility of overturning their sentence.
but then whose burden is it on to figure out if it's overturning the sentence? Is that the law librarians? There's a form that needs to be filled out for legal photocopying that is part of the NCCI procedure. It's actually, I apologize, it's also part of the CMR.
I'm sorry to interrupt you. We're here on a motion to dismiss a complaint. It seems to me that these type of issues should be discussed later on. Like there's no plausible. Your burden is that he's got no plausible claim for relief on this. There's no plausible claim that this is a related to his criminal litigation.
So, Your Honor, let me back up. Sorry, let me back up. First of all, he's no longer at NCCI. I'm sorry, she is no longer at NCCI. So the injunctive claims are moved. Second of all, the plaintiff admits that she received photocopying. So there's no harm. Again, there's no actual injury. She admits in the complaint that she received.
So let's unpack that for a minute. So let's say that she does actually succeed in overturning her conviction, but she's incarcerated for an extra 3 days. Isn't that a harm?
But at that point, we can't be speculative now. At that point, then,
But you're saying there's no plausible claim for relief here. And we do know she was delayed 3 days or 2 days, something, but she was delayed.
Your Honor, I don't see anything in the record other than what she testified or what she argued today about the delay. There's nothing in the record before you that I recall that talks about any kind of delay. That was in response to Your Honor's questions. That was not in the record, and that it was not in the court below.
Can't we infer a delay from the fact that the request was denied and then later the superintendent came? I mean, it didn't happen overnight, instantaneously.
But Your Honor,
Paragraphs 16 and 18 of the plaintiff's complaint give the dates of when those things happened. And that shows that there's at least a 24-hour delay.
Can I ask you about, so your position is that it's moot because the plaintiff is no longer at the same facility. So DOC can pretty much transfer people around with their discretion a lot. So you're saying that the law is that you can just transfer people away to make their claims moot?
No, Your Honor. So NCCI Gardner is a medium security facility. Sousa Baranowski Correctional Center is a maximum security facility. I do not know what plaintiff's actions led to him being transferred to Sousa. I'm sorry, her. What I'm saying is that, first of all, she has no, because she's no longer at NCCI, her injunctive claims regarding the NCCI Gardner photocopying procedure are moot. Second of all,
is it possible that she could be transferred back to NCCI Gardner at some point?
Yes. Yes. But also she doesn't have standing to challenge the regulations.
Even though she was directly injured by it? No standing?
Yes, Your Honor. The case law is pretty clear that that the plaintiff has no private right of action to challenge the agency regulation. And she is challenging, she disagrees with the library services, with the DOC's interpretation of original legal documents. And the DOC, the case law is pretty clear that the DOC is entitled to deference on its interpretation of its own regulations.
What do you say to the plaintiff's argument that calling her a snitch in front of other inmates was problematic?
So, you know, for the purposes of this was a motion to dismiss, at this stage, we have to, you know, the defendants have to assume the allegations in the complaint are true in the lower court. There's no Eighth Amendment violation, does not rise to an Eighth Amendment violation. The law is pretty clear that, that she has no constitutional claim. Derogatory language and verbal harassment are not actionable under Section 1983.
Well, we
She's
do have we do have the Williams versus O'Brien case, which is 78 Mass Appeals Court 169, where we held that deliberate acts by staff that placed a prisoner in jeopardy of physical violence did permit a negligence action to go forward. And the acts in that case, it is a little different, but it is also has overlap. The acts included calling a prisoner a snitch in public and then placing him in a cell with someone was known to have threatened to kill him. He was in fact stabbed, although not in the cell, it was somewhere else. I would like to know why that case is different.
Your Honor, I am not familiar with that case, but I can tell you based on the record before you, that was the record in the court below. I'm sorry, I'm just trying to find the specific allegation that plaintiff just says that he was just called a rat snitch. She does not lay out anything about any potential harm. I'm sorry, and I do apologize. I'm just trying to find the specific.
There is actually federal case law that in the federal circuit seem to be divided. Some seem to require that the prisoner then subsequently be harmed by other prisoners, but some cases seem to not require any harm, that just that label is so toxic that it's just inherently dangerous and that's enough to clear a motion to dismiss bar. So the First Circuit does not seem to have weighed in on that, but we do have this Williams case. So, I mean, do you think, a regular inmate in a DOC facility would want to be called a snitch or rat by a staff member?
No, you're
right. Is it plausible that they might be harmed by that?
Your Honor, yes. I mean, it's also, I can also assert that I don't think there's any staff members that want to be called names by incarcerated individuals. There's no, based on the record before the court, there's nothing, plaintiff just asserts that defendant Murphy called him a rat snitch in front of inmates. And defendants
very loudly in front of a lot of inmates. Go ahead and rat on me, rat snitch. It does not do anything.
Yes, and that is just the allegation. And the allegation, again, that does not rise to an Eighth Amendment violation.
Could it be defamation?
Without having the definition of defamation in front of me, I guess it possibly could, but that's not an allegation brought here before this court or was brought in the lower court. And again, that goes to the motion to dismiss standard at the motion to dismiss stage, that we're assuming the allegations of the complaint are true.
Assuming for the sake of argument that someone coerced Ms. Gibson into becoming an informant in exchange for the photocopies, why is that not a plausible allegation of a violation of the Massachusetts Civil Rights Act?
Well, First, there is no right to unlimited photocopying. So when you talk about under the Mass Civil Rights Act, it has to be a right. So there is no right to unlimited photocopies. And by plaintiff's own admission, she did not become an informant. She says that she was given the photocopies, and later she says in her complaint that she wouldn't do it when she approached it. So there's no coercion. She said no. And then again,
Didn't she say yes and then said no?
she does allege that she first said yes and then she says no, but she didn't do it. She said she didn't do it. And again, there is no right. What is the right that has been interfered with? Because there is no right to unlimited photocopies.
Do we know how long the Boston PD public records letter was?
I don't know, and I don't believe there's anything in the record that says that.
So Gibson cites to Irving versus Dormeyer, an Eighth Circuit case, to support the argument that defendant, I think it's Murphy, violated the Eighth Amendment rights by calling them a rat snitch. I didn't see you cite that case, so I was wondering what you think about Irving, why it doesn't apply.
I think I apologize, Your Honor. I don't have that case in front of me. I would, rely on the cases that were cited in my brief, that the appellees submit that there was no Eighth Amendment violation.
All right, so we're at the time is up. Do any of the other justices have any questions? Okay, so I think that'll do it. The case is submitted. We'll get back to you as soon as we can with a decision.
Thank you.
And we'll be in recess.